morning, Mr. Ferguson. Good morning, counsel.
Good morning, Your Honor.
Okay, we're on the record now in 22 TRC 6333 and 22 CRB 1212. Both styled State versus Herbert Ferguson. Mr. Ferguson is present to be sentenced. He is here with counsel. Counsel, please state your appearance.
Daryl Kowalski for Herbert Ferguson.
And we have a counsel for the state present. Would you please state your appearance?
Thank you, Your Honor. May it please the court, we have you in here to prosecutor.
Very good. All right, counsel, you want to start us off? Go ahead.
Yes, Your Honor. May it please the court, first of all, my client and I have reviewed the PSI in this matter and have found everything on there to be appropriate and accurate to the best of our knowledge. Mr. Ferguson is very sorry for his actions that caused him to be in front of the court here today. This experience both humbled and embarrassed him. He felt overwhelming shame and guilt throughout this process for the children he was placed in charge of, for the unnamed other members of the public he placed in danger, and for what he put his family through due to both the publicity and the normal repercussions of a matter such as this. As this court is aware, many defendants facing the charges Mr. Ferguson was initially charged with here take a wait-and-see approach to get counsel's input, advice, and long-term strategizing prior to taking any action. Some seemingly enter treatment to get out of jail, some in the hope that they'll avoid it with the likely possibility of getting jail credit. Mr. Ferguson, however, entered treatment here on December 1st, 2022, a day before his arraignment, and my first discussions with Mr. Ferguson were not until the next day. He was someone who was very much committed to his treatment process. He was fully involved and engaged with me regarding both my representation of him and his treatment independently. He called me weekly on Friday afternoons, and we often discussed not only court updates about what was going on here, but also discussed his treatment progress. And I would say from our discussions and those I had with some of his counselors that he took it very seriously. I have some documents for the court, Your Honor. And they're separated into 3 different sections. The first is a letter from his therapist at the Bluffs, where Mr. Ferguson attended treatment. That's from his therapist detailing his participation in the inpatient program from December 1st to March 26th of 2023. That's 116 days that he spent in inpatient treatment. I'll note that he entered in his COP here the very next day that he checked out of treatment and was placed on alcohol monitoring the following day, of which I'm aware he has not had any violations for. The next document in that first section is also from a new treating therapist, showing that he has continued his outpatient commitments. He will also detail for you himself his continued plan to attend AA meetings and his plans to continue with treatment at Refuge Recovery via the Hope Institute. He's also engaged with adult children of alcoholics. He only hasn't begun some of those to date because of his lack of license and privileges. To compensate for the time being, Mr. Ferguson is still attending Zoom seminars through the Bluffs, where he attended his inpatient. They take the form of AA meetings and recovery-based discussions via group counseling, the group counseling alumni coordinator there. The next set of documents are letters of support from Mr. Ferguson's daughters. They describe him in their initial letters as an ideal father throughout their lives who has been struggling with addiction in recent years. Their follow-ups from the last week detail their experiences with him since he has been out of recovery and how they see a bright future for him. The third set of documents pertain to the closest case I can relate to this one, and it's a sentencing order. A case from this court, the State versus Andrew Sasala, and his sentencing on an OBI and child endangerment charges. He operated a special needs bus while intoxicated. This includes a probation violation sentencing as well for Mr. Sasala here in this case, and some news articles that give context for his incident. I'll also note for the court in 22 TRC 05244 from September of 22 in the Lyndhurst Municipal Court, a bus driver was caught for weaving on the freeway of I-71 and arrested with a .198 blood alcohol content. She completed a 3-day driver intervention program and was given $500 in fines, a license suspension of 1 year, and offered to wear an alcohol detection bracelet, or ordered to wear a detection bracelet for 90 days in complete mental health and addiction treatment. The Solon bus driver was also arrested with a .07 blood alcohol content after a random test on December 21st of 2023. 2022, in 22 TRC 06463 in the Bedford Municipal Court, she was given credit for a 3-day driver prevention program and given 177 days suspended and a 1-year suspension. Mr. Ferguson is not trying to shirk his responsibility. He hasn't done that with me. However, he did win through no fault of the Medina Police Department or the prosecutor's office here. Obviously, the BAC was thrown out in this matter. He had the opportunity to proceed to an appeal, and I don't know the likelihood of that, Your Honor, and I don't know if the prosecutor could as well, but ultimately he decided he wanted to take responsibility in front of this court. He didn't want to put his family through any additional harm or attention that he had already caused for them. Your Honor, I'd ask for time served in light of Mr. Ferguson's treatment and continued commitment to his sobriety. I'd ask for the allowance of driving privileges once he pays off costs and fines here, and the termination of his ALS suspension as the OVI charges here have been officially dismissed. I'd ask also in light of the loss of his employment and his last 4 months of inpatient treatment that costs and fines are kept minimal and that he be allowed time to pay.
Okay, thank you. Mr. Ferguson, anything you'd like to add?
Yes, I will. I want to thank you, Your Honor, for letting me have this opportunity to address the court. I want to begin by apologizing to the Medina Municipal Court, the law enforcement officers involved. I also want to apologize to the parents and the students on bus number 30. Sincerely sorry for any pain and inconvenience or suffering that I have caused. I also want to apologize to the Medina City School District, to the Transportation Department, and to the community at large here in Medina. And last but not least, I want to apologize to my wife of 35 years, Carla, my daughters, Cassidy and Addison, and my 6 grandbabies. I'm so sorry for the pain and disappointment and embarrassment I have caused you. Leading up to this incident, Your Honor, my behavior was that of a person who had lost his way. I felt out of sync, out of purpose, and out of touch with my life. My coping skills were insufficient and underdeveloped. I was using alcohol as one of my coping skills. As it turned out, alcohol wasn't my problem, it was my solution. I remember the statement I had heard once. It said, "You can wreck your future by running from your past." This rang true for seasons of my life, seasons when all my attention and energy became transfixed on my past, including, and most serious, my very terrible decision to report to work that day. I've suffered guilt, shame, remorse, regret. All the coulda, woulda, shoulda moments left me less than at my best and not present in the moment. I did not want to live this way, so I made a choice. I surrendered. I checked myself into the Bluffs, a rehabilitation facility, and I laid it all out on the table when I got there. I was willing to do anything to change my life, to save my life. I attended and actively participated in recovery, educational, and faith-based groups, 8 hours each day, 7 days a week for 4 months. I met with my therapist daily to talk, delving into my past, to understand and reprocess events in my life. I know I can't change my past, but I can heal and grow from it. I have learned acceptance, gratitude, mindfulness, compassion, forgiveness, and love. During my time at the Bluff, something changed inside me, my spirituality. I could feel a physical and deep emotional transformation. This is the way I will live life moving forward, with a purpose. I am now able to look in the mirror and be proud to be a better man than I was the day before. Recovery is more than just a word, it's a lifestyle. To continue this lifestyle, we'll stay connected by participating in recovery programs and helping others. I will participate in AA, refuge recovery, adult children of alcoholics, SMART recovery. I also continue to talk to my main therapist weekly at the Bluffs. I also participate in recovery groups with counselors from the Bluffs via Zoom weekly. I am seeing a new therapist here in Westlake as well. I see her twice a month. Again, I am sincerely sorry, but this has been one of the most significant experiences of my life. It truly saved my life. Thank you, Your Honor.
Thank you. The state wish to be heard with regard to sentencing.
Yes, thank you, Your Honor. Again, may it please the court, Matt Lanier on behalf of the City of Medina Prosecutor's Office. The state of Ohio acknowledges that the defendant has accepted some responsibility in this issue, and we recognize that he has proactively engaged in seeking treatment for his use and abuse of alcohol. But that, in and of itself, does not forgive the conduct that occurred there. Parents in this community place their most prized possession, their children, in this man's trust. They walk their kids to the bus stop, watch their kids get on the bus. He had kids of different ages, and they had no idea what they were placing their kids into at that point. He was convicted of 6 first-degree misdemeanors here. So, our office in the state of Ohio is seeking a significant jail term and some significant probation following that. And I don't want to forget, it wasn't just the kids that were in danger as he was driving. He placed himself in danger, and this is a 12-ton bus. Every other vehicle on the road, every other pedestrian walking on these roads around these schools was also at risk. So, we're really, really, really fortunate that this didn't turn out worse than it did. But we're hoping you would impose an appropriate sanction today. Thank you.
Thank you. Are the parents of any of the children involved in this case present who wish to be heard? Do you wish to be heard, ma'am?
I do.
That's just yes or no. If you do, you
No.
can. Okay, very good. Because if you
I'd
do,
like to write a letter later.
yeah, okay. Anybody else? All right. All right, the court has reviewed multiple bits of information in considering the sentence to be imposed in this case. That included the complaint in the case, which laid out the essential allegations, the police department incident report, which included numerous significant details here. Notwithstanding the court's ruling on the motion to suppress, the blood alcohol concentration came back at a .135, somewhere between .135 and .138. Notably was ascending between the two test results, which suggest that the rate at which your body was metabolizing alcohol had not yet peaked. That's a significant fact here. There were several admissions in the police report, incident report, admissions that you had made about having vodka in the Gatorade bottle which you were drinking. The names of the 25 high school and middle school students who rode on your bus that day are listed in that report. The report notes that the route that you were driving that day was between 6:45 a.m. and 8:50 a.m. So we are talking about BAC levels like this before 9 o'clock in the morning. Another significant fact. There was a video on the bus that recorded you taking drinks from the Gatorade bottle at least 6 different times while you were driving the bus. The dispatcher noted that your route deviated that morning from the typical route, that your typical layover was at Claggett, not at the high school. They said that that was a factor to be considered. And the court also notes that between December 1st of last year and March 26th of this year, you checked yourself into Bluffs Treatment Center and are taking the problem that you have seriously, because that's the long-term hope for you personally. The court also reviewed the pre-sentence investigation materials, which included the questionnaire and profile, which you completed. There were several admissions about your misconduct that day. In that profile and questionnaire, your quote was that you made a bad decision to report to work and alcohol was detected. That is a significant understatement of what went wrong here, but that is at least what happened. You also noted in that questionnaire that you were a daily drinker. In fact, I note in one of the letters of support from your children, one of your children comments that you needed to drink daily just to stabilize. The court reviewed the victim impact statements that were received. They can be summed up in one observation by at least one of the parents saying this was just a massive violation of trust on your part with regard to the school children that were in your care. The court also reviewed the terms of the pretrial agreement, which was struck in this case. Notes that the state had agreed as a condition of your returning a plea of no contest to the charges here that they would avoid filing additional charges with regard to the remaining students who were on the bus that you were driving that day. And the court also conducted its own independent research on sentencing in endangering children contexts which are like this one, and they're almost impossible to find. There are significant distinctions between the Sasala case and this one. If for no other reason, the circumstances of the drinking while you're driving, the number of children who are on the bus, the strong inference that this was not the first occasion that this happened. I mean, the materials that were supplied today by your counsel reinforced the notion that this likely did not happen this one and only occasion. So all of those factors were reviewed in preparing the sentence for today. The court is also required by law to craft sentences in misdemeanor cases which serve two primary purposes. One is to punish the offender, and the other is to protect the public. And in preparing those sentencing entries, the court is directed to several factors which it has to consider. And I'm going to list those factors for the record so that you understand what goes into a sentence such as the one being imposed here this morning. The court is required to consider the need to change the defendant's behavior, which I think everybody in the room agrees, including you, is significant in this case. The need to rehabilitate the defendant, which is significant in this case. The impact on victims. The court spent some time going over the factors for sentencing in preparation of this sentence with probation department personnel. And there are very few ways that this could have been worse and stayed in this court. There are very few ways that this could have been worse. The court is required to consider the consistency of this sentence with other sentences for similarly situated defendants so that you don't get treated differently than anyone else in your situation who presents with these facts. And as I say, the analogies are spare. Very hard to find another case like this, even in the decided case law. Court is required to consider the nature and circumstances of the offense, the history of the defendant's criminal activity, which is null in this case, the defendant's character, the substantial risk of reoffense, which remains real. If you've got an alcohol problem of the magnitude that's described in these documents, that's something you're going to be dealing with forever. And it's not uncommon in this court to find people who come through this court being sentenced on alcohol-related offenses who come back later on alcohol-related offenses. So, you're obviously encouraged and, supported in your efforts to take care of this problem, but it's going to be something you've got to be vigilant about forever. And there's no guarantee that you don't come back facing similar problems like you're facing here this morning. Court is required to consider the danger that the defendant poses to others, which the prosecutor alluded to here. The danger that you presented on this particular day was not just to yourself and the children, but to every driver on the road. Court has to consider patterns of repetitive or compulsive behavior or heedless indifference to consequences. No real patterns are established here except for the implicit one, the inference that is drawn from your issue with alcohol and the fact that you've been driving buses for, 2 or 3 years? Court is required to consider the likelihood that you will commit future crimes and any other relevant factors. So those are the statutory factors that have to be considered here, and the court has carefully and painstakingly gone through all of that in arriving at the sentence today. The court notes for the record that pursuant to Ohio Revised Code 2929.41B1, in misdemeanor cases where the court runs consecutive sentences, it is limited to 18 months. So you could have 20 first-degree misdemeanor offenses of which you're found guilty in this court. The court would, in any case, be limited to imposing a maximum consecutive sentence of 18 months. So that is a governing principle in this case. So having considered all of those factors and attempting to balance all this out, it goes without saying there's no sentence that perfectly balances all these factors. We're attempting to achieve justice here. That's the point of it. But the primary aggravating factors in this case are the trust that you violated by putting all of these school kids at risk. That's really hard to get around. This is not like other cases in the case law where people are out with their own children in the car, driving impaired, which is reckless enough and bad enough. But here you are charged with shuttling kids to and from school, being video recorded, drinking on the bus while you're driving. It's a significant violation of trust, the public trust, and the faith that these parents put in you to safely shuttle their children around. And as I say, you have to balance into this your attempt to address the problem. That's all good. Good for you. Good for your family. But it's hard getting past this situation here. There were 25 school children named in the police report. I heard different reports that there may have been 30 or more, but there were at least 25 named in the report. You know, kids who were on your bus that day. And, you know, I have to believe, just based on what you've said here this morning and on what's been said on your behalf in these documents, that you think about that every day. And you should. So balancing all of those factors under the statutes in consideration of all the materials in the pre-sentence investigation, the sentence in this case will be as follows. There are 6 counts of child endangering on which you've been convicted. The fine for those convictions will be $500 on each of the counts for a total of $3,000 in fines. The court will give you 12 months to pay the fines and costs in this case. The court is going to impose 180 days of jail time on counts 1, 2, and 3 of this case to run consecutively. The court will impose no jail time on counts 4 through 6 because, as I said, the court is restricted by law to a maximum of 18 months of consecutive time. The court will suspend 270 jail days. You'll serve the other 270 days beginning today's date. You'll be placed on probation with this court for 5 years. That involves a probation service fee of $490. During the term of your supervision, you are not to commit another local, state, or federal crime. You'll report to our probation department as directed. You'll be further assessed for drug and alcohol abuse and directed to treatment as the department deems appropriate. You are not to possess or consume alcoholic beverages during the term of your supervision. That's a zero tolerance policy. You have 1 drink and we find out about it, we'll be back here talking about suspended jail time. You understand that?
Yes, sir.
You're not to refuse to submit to a chemical test of blood, breath, or urine at the request of law enforcement or the probation department. You'll seek counseling as the department directs. You'll be subject to random drug screens and shall not test positive for any controlled substance. Upon your release from jail, you'll be placed on scram for 90 days at your cost. Probation department will make sure that that gets arranged. Your driver's license will be suspended during the term of your probation. You'll be eligible for limited driving privileges with an ignition interlock device required. You'll have to pay all the fines and costs and show proof of insurance before you're eligible for the limited driving privileges. Any questions about the sentence?
No, sir.
All right, good luck.
Your Honor, how long was the term of probation?
5 years.
Thank you.
All right, good luck to you, sir.
Thank you.
We're in recess.
All right. You can be seated. Yeah, go ahead. Hope I can stay out of your way.
Thank you.
We have Hoffman, ready to go. Rednicki, ready to go. Martin,